All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. We're here today in there's a long case at SWAIN versus BIXBY Village, and it's 1 CA CV18-0397. Each side will have 20 minutes to present their argument. You may reserve any time that you want for rebuttal, but you'll have to keep track of the time yourself. While we have a clock at the podium, we are recording this argument. It'll be on YouTube in a couple of days, so when you begin your argument, please identify yourself and your client so that we can keep everything straight. We have read the briefs. We've conferenced the case. We've talked about this case extensively, so we're familiar with the facts and the law. So when you begin your argument, just launch right into what you want us to discuss. So, with that in mind, counsel, please begin.
Good morning, Your Honor. May it please the Court. I'm Dan Maynard on behalf of the appellants, which are TTLC, Ahwatukee Land Investors, and BIXBY Village. I should also tell the Court, as we mentioned in our opening brief, the current owner of the property that's in dispute is an entity known as ALCR LLC. Your Honors, this case involves three primary issues. The first is, did the CC&Rs that were on the subject property that were put there starting in 1986 and then amended in 87, 88, and 92, do they require that the owner of the property run and operate a golf course? Two, we contend that it is not. Second, I want to look at the issue of whether or not the injunction that the court issued in this case is overly broad and unenforceable. We believe that it is. And then third, the third issue is whether or not there was a modification warranted because of the change in circumstances here.
Counsel, if the CC&Rs don't require your client to run a golf course, what's the option? What's the alternative? What else is there?
It goes back to its natural state.
Okay. So that's the dichotomy. We drive down there now, take a picture versus a golf course. Is that correct?
Yes.
And so it's a question of intent of the folks who entered into the CC&R?
To some degree, that's correct.
And whether or not they intended a golf course or what's there presently?
I don't agree with that proposition. I think the question is, the intent was, if you're going to use the property, you must use it for a golf course.
Well, counsel,
but you don't have to use the property.
but counsel, I'm concerned about that because when I look at the deed, the original deed restriction, it says that the land must be kept so that they get the benefit of the tax valuation statute. It's in the 1986 deed restriction, and it's in the 1992 CC&R. By recording this declaration, the declarant intends to comply with the requirements and obtain the benefits of the tax valuation statute. If there is no golf course, then no one can get the benefit of that statute. Given that the deed restriction and the CC&Rs require that the land be kept to comply with the tax valuation statute, which requires a golf course, how can you read anything else to say that it's either a golf course or nothing? I understand that language in isolation might indicate that it's an either or, but when you look at having to comply with the statute, how do you get around that?
If you want the benefit of the statute that gives preferential treatment for tax purposes for a golf course, you have to comply. And one of the rules was that you have to file deed restrictions. They had to be in writing. That's all that was done here. The intent of the parties was it was a contract between the declarant and the assessor that we want to take the opportunity to get this benefit, which is the golf course. But they weren't required to. There's nothing in there where the assessor would say, oh, you signed this agreement with me, I'm going to make you run a golf course. What the assessor would say is, you're not running a golf course, you don't get the tax benefit.
But F says the declarant intends to comply with the requirements and obtain the benefits of the tax valuation sector. That's in the CC&Rs. Aren't they bound by the CC&Rs?
If they're going to use the property, they are.
But I don't understand where the condition is stated.
Your Honor, let me give you an analogy.
Well, but I'm looking at the document, and where in the documents does it give you the option?
Because the option is I never have to use the property.
Where does it say that?
Well, because this is a negative declaration. It basically restricts my use of the property. It doesn't affirmatively make me do this.
A requirement that you comply with the statute is a negative restriction?
No, it's not. The requirement that I comply with the statute is only to get the benefit of the tax benefit.
Which is the whole purpose of this.
I'm sorry, Your Honor.
Which is the whole purpose of those terms in the deed restriction and the CC&Rs.
It certainly is, but it's not. The state is not requiring me, or my client rather, to build a golf course. It's basically requiring that if I am going to get the benefit of this regulation, I'm entering into a contract basically with the state that says if I want this benefit, I have to have CC&Rs that are in writing that allow me to use this as a golf course or restrict that use to a golf course. If I don't use it as a golf course for whatever reason, the state's not going to require me to do it. I just don't get the tax benefit.
I'm not saying, at least as I understand it, I'm not saying that the state is requiring you to have a golf course. My reading of the deed restriction and the CC&Rs indicate to me that the agreement requires a golf course. And I guess my bottom line question is, where in the language of the deed restriction or the CC&Rs does it give the option of either having a golf course or not having a golf course.
Your Honor, when you look at the 1992 deed restrictions, paragraph 2,
Yes.
it says the property shall be used for the purposes, for no purposes other than a golf course. It goes on to state later in that paragraph that except that the property may be further used for easements of ingress, egress, vehicular or otherwise, pedestrian trails, walks, gables, whatever. It then goes down further in that paragraph that says, no improvement shall be made, constructed, installed, or located on the property that is not reasonably related to the convenient use or in furtherance of the aforementioned purposes,
Yes.
plural. If it was only a golf course, one, it wouldn't be, purposes would be singular. The purpose was a golf course.
Well, the first sentence of that paragraph says the property shall be used for no purposes. So that's plural too. That's a mighty thin reed to hang this on.
Well, I think it is a reed that I can hang my hat on. But secondly, you go further down in that paragraph, and it provides that the declarant reserves the right to redesign, reconfigure the golf course, or remove, modify, alter, relocate, replace, expand, abandon,
Okay, well, let's explore that. And then I want to go back to
or
my
cease
first
use.
question. Paragraph 2. It says in the at the very beginning, it uses the words. It's the property shall be used for no purposes other than golf courses and such improvements and facilities. You're saying that's all one and the same because the language you're referring to that talks about abandoning is tied directly to the improvements and facilities, which I think indicates a clubhouse or restaurant. It does not modify golf courses. And if it does, how am I missing? There's an and
I agree
between golf courses and improvements and facilities.
I agree with what you've just said. But when you go down to the last sentence where it says, abandon, demolish, cease the use of, or rebuild any of the improvements or facilities. Your Honor, does any mean, in our interpretation, it means it could be all.
Oh, and I don't disagree with you.
So-
any of the improvements or facilities, which falls squarely outside the use of the word golf courses in the first sentence.
Your Honor, to have a golf course, you have to have all of these particular facilities. You have to have greens, you have to have tee boxes, you have to have clubhouse.
Right. I didn't write this. It says golf courses and improvements or facilities. And then it goes on to talk about all the things you can do with improvements or facilities, not golf courses.
But the improvements or facilities are part of the golf course. You don't have a golf course. For instance,
Is there somewhere that it says that?
no, but that's just common sense, Judge.
Well, common sense says it's written as it's written.
I'm not the drafter.
Well, but our job is to determine and enforce the intent of the initial parties to the agreement. And if it specifically, using the word and, separates golf courses from improvements and facilities, what doctrine of construction do we use to blend those?
Your Honor, you have to look at the entire writing together. There is no evidence in this record other than this document as to what the intent of the parties is. We didn't have the draft. There were no testimony from any of the drafters. I wish there was.
And let me go a little bit further on my first question, because rather than sort of look at it as an academic sort of law school question, whether or not you have to operate a golf course or not, don't we need to consider what the alternative is?
Yes.
Right? It's not just whether it makes economic sense and whether you need to operate a golf course. It's you have a community built around property, and what was the intent of the original developers and homeowners? Did they intend when they wrote that, I think you call it not affirmative covenant, that they were fine with buying the house as long as it was a golf course or overgrown jungle? Is that how you have to interpret it?
No, I wouldn't say that, Your Honor. I mean, that's part of the problem here. We don't know what the intent was. One of the plaintiffs in this case bought the house in 1984, prior to the CC&Rs. Was she relying on them? Clearly not. They weren't in existence at the time. There's nothing in here that indicates that anybody paid a premium because they were living on a golf course. That's not a finding of this court. It's not in the record because we just don't know what it is. But
you'd agree with me, though, that in assessing the intent, it's not just the question of whether or not your client must run a golf course. It's whether your client runs a golf course or we have what's there today. That's the question.
Yeah, the question is, do we have to run a golf course, or can the land just stay fallow, or in its natural state? I mean, look, what the plaintiffs really want, they don't care if there's a golf course. They want something that's green and lush, and that my client would have to pay money to keep it up, whether it's a golf course or not. These plaintiffs don't even play golf. I mean, they want something that looks beautiful that somebody else is paying for. All right? What the judge did in this case in the injunction, I'm going to try to reserve some time, but I mean, the judge says that what the owner must do is create and operate a golf course that is consistent with the reasonable expectations that the Lakes Golf Course created among the benefited homeowners. Judge, as it indicates here, a golf course, I played at Bandon Dunes. It's dirt up there. In Scotland, they're dirt. They're not necessarily green. There is nothing that indicates what kind of golf course has to be there. Can it be a 9-hole? Can it be 18? Could it be a putt-putt golf course? I don't know. It doesn't say. It says a golf course.
Counsel, I might agree with you that it could be the ugliest golf course ever designed, and that would satisfy the deed restriction in the CC&Rs. But it has to be a golf course that complies with the statute. So I'm just having difficulty in seeing how, when you read all of the documents together, you can say it's either or. And to go to the language that you were discussing earlier, that you have the right to abandon, demolish, cease to use or rebuild any of the improvements or facilities. That goes with the improvements and the facilities, but if you go earlier in the sentence, you only have the right to redesign or reconfigure the golf course. It doesn't seem to give you the right to do away with it altogether.
Well, it seems to me, Your Honor, that when you read that language and you look at it all together, it doesn't indicate that the intent was you only can modify this or you only can modify that. When you're talking about reconfiguring, I mean, This is an 18-hole golf course. Could it have been a 9-hole golf course? Yes. Could it have been an executive? This was an executive cool. Could it have been a par 3 golf course? Sure. I don't know that it could have been a putt-putt.
Well, but in all of your examples, it's a golf course, and I assume without studying, it would meet the statutory definition of a golf course. And that would seem to be all that the plaintiffs are entitled to. But it's got to be some kind of golf course.
Your Honor, can I reserve my last 2 minutes?
Yes, please. Counsel.
Good morning, Your Honors. My name is Tim Barnes. I am the counsel for the plaintiffs in this action. And I spent a lot of time in the process of this case thinking about this case. And from my perspective, as I thought about how can I say something different today, a thought occurred to me that this case is about choices. This case is about choices that have been made by various parties over periods of time. But this case started in 1986 when someone made the choice to create a deed restriction incorporating the statute at the time, the Golf Valuation and Taxation statute at the time, which was 42-146. And so that really is what set everything else in motion. And originally it was drafted so that the county assessor would be the sole beneficiary of the decision to make this restricted to a golf course. And then, and that original covenant was for a 10-year period.
Counsel, so let's look at the 92 covenant and subsection F, which says the declarant intends to comply with the requirements and obtain the benefits of ARS 42-146. That's the statute you're referring to?
Yes, yes.
Okay. Intends to comply, is that a firm requirement or is that an aspiration?
Well, under the statute, and the statute of 42-146 used to be a really long set of statutes that incorporated virtually verbatim everything that's now in 42-13, 151 through 154. There's no 153 any longer. And so all of that was put essentially into 146. Now, one of the provisions in there is that when you agree to do this, it talks about there's a covenant then between the county and the property owner.
And is that sufficient? The word intend, again, that's what I want to focus on now.
Understand.
The word intend. This doesn't say the declarant agrees to meet the requirements and firmly do whatever needs to be done for these tax benefits. It says we intend. Isn't that an equivocal? I mean, would you concede at least that's more equivocal than agree?
It's not a compelling requirement. I'll concede that, Your Honor. But I think, again, one of the issues with the appellant's description of the paragraph 2 is they're looking at that in a vacuum, and they're looking at a portion of paragraph 2 in a vacuum as if the rest of the contract wasn't there. And to me, you have to read the 142, the 42-146 together with the other provisions of the contract, one of which is the use provision in 2, but then you also have to look at the modification provisions in 6 and 10. Because paragraph 6, which obviously is front and center in the appellant's arguments, allows them to, the owner to determine that there have been material changes, okay? Or you can go to the homeowner's community and get 51% of the community to change. So it seems to me that the 146 can't be read in a vacuum. It's got to be read with the fact that this is a use restriction. And the two are really intertwined in the context of what is this contract about.
Well, Counsel, when you look at the deed, the 86 deed restriction itself, it says, that the owner hereby makes this deed restriction pursuant to 42(1)2501, restricting the use of said property to use as a golf course, and then it says, that the restriction may be amended subject to the statute. Is that a stronger indication than the intent, or it intends to statement in the CC&Rs that a golf course must be built?
I believe it is, Your Honor, because originally that's all we had. And all they were thinking about was complying with the statute so that they got that tax valuation. And it's a substantial tax valuation. And it wasn't until then Judge Ryan, later to be Justice Ryan, who wrote in, and I can't pronounce it, it's the PHXAZ case, where Judge Ryan was construing the intent of that statute to require that it be operational golf course. And Judge Ryan was looking at the definition of the golf course in the statute, which when you read the definition of the golf course in the statute, it's identical to what it is now. And if I may, Your Honors, a golf course means substantially undeveloped land, including amenities such as landscaping, irrigation systems, paths, golf greens, and tees that must be used for golfing and golfing practice by the public or by members or guests of a private club.
Well, counsel, so do we read anything into that the 86 was firm and the 92, I guess, at least pivoted somewhat? Is that significant?
It did,
it's
other
different
than
later in time?
I apologize, Your Honor.
Go ahead.
Each of the subsequent amendments incorporated by reference the prior amendments. So all of the 86, 88, 7, and 88 are brought into the 92. But to the extent the court is the least bit concerned about equivocation on that issue, again, if you read it in the context of the use restriction and the other provisions for modification, it seems me that you have a very solid basis on which the trial court's ruling was made.
Let me ask you a question, though. Really, the touchstone of this case is intent. The intent of the parties, the founding fathers of the community. Is that correct?
Yes.
So we're not talking about binding contractual terms. We're trying to divine the intent of people from a document that uses the word intent to build a golf course.
Your Honor,
is that significant?
You're reminding me of a portion of when Justice Ryan wrote Powell versus Washburn. And there the CC&Rs were debating over what kind of house or residence could be in the community. And Justice Ryan then wrote that, look, you don't have to rely on the express words to divine what the purpose of it was. You get the purpose of it from the entirety of the document and any other circumstances you have. The plaintiff, the defendants, the appellants say, well, there's no other extrinsic evidence relied on here. Well, of course there is. The extrinsic evidence are the 86, 87, and 88, and frankly, the statute, because it's the statute that is driving everything, because that's what was in the 86.
Well, and I want to clarify with you. So the only evidence, the only documents we can look at are the original deed restriction, the amendments, and the CC&Rs.
Correct.
There's no other quote extrinsic evidence about what the founders of the deed restriction intended. All we've got is what's on paper.
That's correct, Your Honor. That is correct.
And then a question that I've had, your colleague noted that what the homeowners really want is something green and lush. And while I think that may be true, to comply with the tax valuation statute, as long as it's a golf course that you can play and practice golf on, I assume it could be the ugliest golf course ever designed, which may not make the homeowners very happy because it may not be pleasing to look upon, but it would meet the deed restriction and the statute. Do you have a view on that?
I don't disagree, Your Honor, that the 92 CC&Rs do not talk to us about what kind of golf course. It simply refers to a golf course. But with all respect, I've been in this valley long enough to remember when there were sand golf courses out in Apache Junction, and that's a golf course. I get that. But at the same time, given the context of the track of owners that owned this property and maintained it, when these owners acquired the property, it's a stipulated fact they had no intention of doing anything other than to develop the property. So for them to complain about they have to comply with that, even though it isn't, there's no specific requirement. And all the injunction does is require that they restore the golf course. That's all it does.
If they did operate a sand golf course that wasn't aesthetically pleasing, would we be here today?
I'm not sure we would. But the reality is, no one pays $9 million to build a sand golf course.
So, counsel, the Supreme Court in Powell identified, pointing to 4.1 of the restatement, 3 areas to look at to interpret a restrictive covenant. Is that right?
Yes.
And the first was language used. The second is circumstances surrounding creation, and then the purpose for which the covenant was created. Is your argument exclusively premised on that first element, or can we, how do we look at the circumstances and the purpose and get in the point that I was trying to make originally, which is that the Founding Fathers, if we could go back in time, when presented with the option of golf course or overgrown lot, meant golf course? Or are we just limited exclusively to the first element to the exclusion of the other 2?
Well, it seems to me you get the circumstances from the 86, 87, and 88 documents and then the 92 documents in the context of the statute that's driving everything. And that statute really hasn't changed other than they've changed the numbering. And
so you're in agreement with my earlier question to you. All we're going to have are the documents. We get no other testimony, no other evidence other than that.
I agree completely, but I don't think any other is necessary, because you can glean the circumstances from these other documents. You can glean the purpose that it be a golf course. You can't glean what type of golf course, and I'm not sure, frankly, it would matter what type of golf course it would be, absent something in the actual contract itself that tells us what kind of golf course. I mean,
I guess I agree that, clearly there's writing, and we can't bring these people back for the court. The question I'm trying to get is, do we consider in this sort of clinical environment whether the question is golf course or not, or is it golf course or what's there today, in divining the intent and looking at these documents?
Your Honor, I don't want to dodge that question. Let me answer it this way. I don't agree that the documents say anything about golf course or nothing. I just don't get that. I don't believe it's there. I don't believe you can even divine that. But I do believe that in understanding what's going on, what you have to look at are those 4 written documents, essentially, based upon the statute, which, of course, you can look at as well. And I believe that's legally sufficient for Your Honors to conclude that this is what was intended.
And Powell, when it talks about looking beyond the written terms to the circumstances and the purpose, how do we accomplish that exercise?
I'm sounding like a broken record. I believe you can do that by looking at the actual original documents.
We have that. That's the first element, which is language used. Look at the text, interpret it, use dictionary definitions. What I'm saying is these other 2 areas in 4.1, which are looking outside the 4 corners of those documents for whatever reason. That's just irrelevant here. Everything is focused on your argument today is we don't look outside the 4 corners of the document here to assess what the land is today. That's what your position is.
I'm not really arguing that you don't look out. I'm just saying if all you have to look at are the 4 corners, that is legally sufficient. Because even though we talk about circumstances, again, the circumstances are reflected by the documents to some extent. Because someone made the choice, let's tie this golf course to that statute, and that's all we're going to do. And then obviously over time they decide, well, wait a minute, let's change that to be a more all-encompassing set of CC&Rs, which is what we ended up with.
So we can look at the circumstances surrounding the creation of the restriction and the purpose of it, but for whatever reason there's not extensive evidence of that in the record other than the documents. So the documents are what we have, and the documents are all that we have to make the determination.
I agree with that, Your Honor. Now, here's the thing. From my perspective, the Scrivener is a Scrivener. I happen to know who the Scrivener is, and I've known him for decades. But asking the Scrivener what he meant isn't suiting the purpose of figuring out what the intent is. To me, it would be going to the people who actually created the document. And again, I just am not believing that as a matter of law that is essential if that's what we have. If there are...
And you're not arguing that. You're as the proponent for that side, you just want us to remain in the 4 corners of the document. That's your argument.
Of necessity, because we don't have anything else, and because I think that it's legally sufficient.
Thank you, Counsel.
Thank you, Your Honors.
Counsel?
Your Honors, we keep going back to intent and when these original 1986 CC&Rs were constructed. And yes, the intent was to have a golf course that would comply with the statute so that the declarants would get the benefit of the tax benefit with the county. There was no intent that it was going to be a golf course for now in perpetuity. Initially, it was for 10 years. It was amended to add another year. It was amended to add 5 more years. But at any time during then, they could have stopped running the golf course. The county would not have compelled them to. They would have lost the tax benefit. That was the intent. Your Honor, if the clients had come in, if somebody had come in and bought that golf course and got a mortgage on it, they paid $4 million for it, they mortgaged the property with Alliance Bank, and they are not doing well economically, and they default on their mortgage, and Alliance Bank comes back in and takes over the property. Realistically, would a court say to Alliance Bank, you have to run a golf course, not only just build it, but you have to operate it? No. I mean, the economic and reality in life is that there's not going to be a golf course put out there. There's no money. Nobody is going to loan money to build a golf course out there. At the end of the day, the client can take that land, the entity that owns it, it's a single asset entity, and put it into bankruptcy and let a bankruptcy court determine whether or not there's been a material change in circumstances. But we don't need to get there because this court gave us an injunction that is much too broad that we can't comply with. We just can't, and nor would anyone else. Thank you, Your Honor.
Thank you, counsel. We'll take this matter under advisement and we'll issue our decision in due course. We stand adjourned.